Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 135. We're back to just doing 3 cases now, and in this episode we've got a case on whether an employee can be dismissed for misconduct, which is not gross misconduct. One of the latest developments in the case of the teacher who showed an 18 certificate film to a bunch of 15-year-olds, and a case on whether a tribunal was able to determine that the correct employer was not the employer identified in the contract of employment. All will become clear. As always, please don't forget you can access this podcast through our website, LinkedIn, iTunes, YouTube, and we put out links to all the cases on Twitter. So first up, City of York Council and P.J. Grosset. This is a case concerned with a slightly odd set of facts, but has a very important conclusion to it. The claimant was a teacher, employed by the respondent. He is disabled, suffering from cystic fibrosis. The claimant asserted that because he was subjected to an inappropriate increased workload at school, as a result his exercise regime slipped, and he became very stressed, and while suffering from this high level of stress, it was accepted that he'd shown a class of 15-year-olds an 18-rated horror film. Halloween, I think. He didn't get approval for this or consent, and when the school found out, he was, I think entirely unsurprisingly, sacked for gross misconduct. His defence was that, whilst he accepted that showing the film was inappropriate, it was an error of judgment arising partly from the high level of stress he was under at the time. When he was dismissed, he brought a series of claims at the Employment Tribunal. His unfair dismissal claim was rejected, but the Employment Tribunal unanimously upheld his claim in relation to Section 15 of the Equality Act. The EAT turned down the Council's appeal, and so the matter has gone up to the Court of Appeal. Section 15 of the Equality Act provides 1. Quote, a person, A, discriminates against a disabled person, B, if A treats B unfavourably because of something arising in consequence of B's disability, and A cannot show that the treatment is a proportionate means of achieving a legitimate aim. 2. 1. The first paragraph does not apply if A shows that A did not know and could not reasonably be expected to know that B had the disability. So, you can be liable for discriminating against someone if you do something unfavourable towards them, which is connected with their disability, and you can't show that it's a proportionate means of achieving a legitimate aim. But if you do not know the person is disabled, couldn't be expected to know, then that duty does not apply. At the Employment Tribunal, the Tribunal found that showing the film had been the result of stress as arising as a consequence of the disability, and that there was no real risk of repetition of such an error of judgment. Therefore, according to the Employment Tribunal, a formal written warning would have been sufficient, and the treatment was discriminatory because it was not proportionate. So, here, the issue was that the employer was aware that the individual was disabled. Therefore, the subclause which I mentioned, 15.2, could not apply because they knew of his disability. Therefore, the question was whether the council treated Mr. Grosset unfavourably because of something arising in consequence of his disability, and was that treatment a proportionate means of achieving a legitimate aim. Remember, of course, that in order to show that the treatment was a proportionate means of achieving a legitimate aim, this is an objective test. The employer does not get a margin of error, a margin of discretion, in the way it does, for example, when assessing unfair dismissal. The council had considered carefully whether or not there was a link between the claimant's disability and his misconduct, but the tribunal, on the basis of further evidence, some of which I think was not available to the employer, concluded there was a link between the disability and his misconduct. The employer tried to argue that at the Court of Appeal that in order to have liability under Section 15, it was necessary for the employer to appreciate the link between the disability and the, in this case, misconduct. But the Court of Appeal rejected this. It was enough if, viewed objectively, there was a link. It was not necessary for the employer to have realised the existence of a link between the bad behaviour in this case and the disability. It wasn't necessary for the employer, in a sense, to be blameworthy for failing to realise there was a link. As the Court of Appeal put it, quote, the risk of unfavourable treatment because of something that has arisen from the disability is cast onto the defendant rather than the claimant. If the defendant does not know that the claimant suffers from a disability, he has a defence. But if he does know that there is a disability, he will be wise to look into the matter more carefully before taking unfavourable action. The defendant will also have a defence if he was able to justify the unfavourable treatment under Section 15(1)(b). Here, the problem was, as I say, that the Employment Tribunal had assessed the employer's actions and decided there was insufficient justification for dismissing him in circumstances where there had been a failure by the employer to make reasonable adjustments to his workload, which had created the problem in the first place. The Employment Tribunal took the view that had such reasonable adjustments been made, it would have been, quote, unlikely in the extreme, unquote, that the incident with the film would have occurred. So there you have it, and I have no doubt that the employer is feeling fairly disgruntled with the state of the law round about now. However, the key point, and it could not have been put more succinctly by the Court of Appeal, is that where you're about to impose an adverse outcome on a disabled employee, such as a disciplinary sanction, you need to be very careful to check if there is a link between the adverse outcome and the individual's disability. Clearly, if what you're doing is going to be justified in any event, then the link is not a problem. But certainly the Court of Appeal drew some support, as the Employment Tribunal had done, from one of the examples given in the relevant Code of Practice. And that gives the example of a woman who is suffering from cancer, who is in pain as a result, and as a result of the pain, loses her temper at work. Disciplinary action, according to the Code of Practice, would be linked to her disability. Clearly, if the disciplinary sanction imposed is objectively justified, then all is fine. This case, which I hasten to add I think is clearly correct on the wording of the statute, undoubtedly causes problems for employers. Remember, the employer had considered the issue of the link, had reasonably come to a view that there was no link, but the Employment Tribunal had taken a different view. I think it will often be relatively easy to assert that there is a link between a disability and adverse treatment where the employee is underperforming, for example, and potentially in many misconduct cases too. So employers are going to have to get used to the fact that they're going to need to justify objectively any disciplinary sanction against a disabled employee unless they are able to convince the tribunal that there was no link between the disciplinary sanction or underperformance and the disability. So that's the case of City of York Council and P.J. Grosset. Next up, Dynasystems for Trade and General Consulting Limited and others, and Mosley. This case concerned the approach to be taken where the employee was saying that the contract of employment wrongly identified a company as his employer, when in fact, according to the employee, he was employed throughout by another company. Here, the claimant was interviewed and offered a job with Dynasystems, and the contract of employment purported to be with a Jordanian company, Dynasystems for Trade and General Consulting. However, on the same day, he was also given a letter signed on behalf of a UK sister company, Dynasystems Limited, to assist him in obtaining a second passport, which was necessary potentially for his work in the Middle East. The employee was subsequently dismissed and brought and won claims for unfair and wrongful dismissal. However, it was also necessary to decide who was the correct employer. The tribunal judge decided that the UK company, Dynasystems Limited, was in fact the employer. The question for the EAT was the test to be applied when deciding whether or not a contract of employment, which expressly named the Jordanian company as employer, was in fact a contract of employment with a UK company. The tribunal judge applied the well-known case of AutoCleanse Limited and Belcher and asked whether the term in the contract purporting to show that the employer was the Jordanian company was in fact a sham, in that it was not an accurate reflection of the reality. The tribunal judge decided that the UK company was the relevant employer because the Jordanian company, for example, had a registered address but had no actual place of business. Therefore, to the extent that the contract said the individual was going to be based at the Jordanian company's registered address, it was clearly wrong. The claimant did not actually do any work for or on behalf of the Jordanian company and worked predominantly for the UK company or a third subsidiary. He was subject to the line management of a director of the UK company, and that was all where all his work instructions came from. The Jordanian company did pay his salary, but the salary was whatever was agreed between him and the director of the UK company. On that basis, the tribunal judge said that she was satisfied that the express term in the claimant's written statement of terms and conditions did not reflect the actual agreement, and it was understood that in reality the claimant would be employed by the UK company. So the UK company is in reality the employer. The group of companies, both the Jordanian and UK company, appealed to the AT, and they pointed to the well-known line of cases dealing with employment agencies. As you'll remember, in cases such as James and Greenwich London Borough Council, the court set itself against readily implying contracts of employment between a customer of an agency and one of the agency workers. There was a contract between the agency and the worker rather than a contract between the worker and the end customer. The reasoning in those cases is that it was not necessary to imply a contract between the customer and the worker. Accordingly, here, the employers argued it was not necessary to imply that the UK company was the employer, and therefore the contract should have been accepted as written. However, the court decided that the agency cases were not directly relevant. In those agency cases, there was no dispute the individual had a contract with the agency to supply their services to the customer. The issue in those cases was whether a further contract should be implied between worker and end user. Here, in this case, the position was different. Here, the issue is who is the contracting party employing the individual. On that basis, the judge was entitled to apply the test that she did and come to the view that the UK company was the correct employer. I wanted to put this case into the podcast because I think it's a useful point. Although it does not get said anywhere in the judgment, I suspect the Jordanian company would have been a lot more difficult to enforce claims against than the UK company. There could also be tax reasons why the UK company did not want to be found to be the employer. Anyway, what happened here was that the contract has effectively been rewritten so that it reflects the true contractual bargain. Given the increasing number of contracts which we see which have an international employment element in them, and that it's often much easier to enforce a contract against a local employer, I can think we'll probably see other cases arising on precisely the same point. However, if you're trying to defend a contract with a foreign employer, and there's no law that says you can't have a foreign employer, it's worth remembering that the individual in this case did no work at all for the Jordanian company, nor was there an assignment letter or similar assigning him temporarily or seconding him to the UK company, all of which might have helped to defend the contract as written with the Jordanian company as employer. And of course, the issue of a letter for passport purposes with the wrong head note on the wrong head note on it was clearly unhelpful. So that's the case of Dynasystems for Trade and General Consulting Limited and others, and Mosley. Third case. Now, I can't say this name. I nearly didn't put this case in the pack simply because I have no idea how to say the claimant's name. So, with all due respect and apologies, I'm going to spell it out. The claimant, his surname was Mbubaegbu, and Homerton University Hospital NHS Foundation Trust. This case concerns the dismissal of a consultant for a first offence. The issue is whether the dismissal was fair or unfair. I should say there were a number of other claims alleged as well by the claimant, which were also dismissed and which I'm not going to cover off in this summary. Facts can be dealt with relatively briefly. The claimant is a surgeon. He'd been employed for 15 years and had, up to the point of the instance that led to dismissal here, he'd had an unblemished career with no question mark over his judgment or abilities and was indeed highly regarded by colleagues. He was dismissed because of alleged failures to comply with rules and procedures introduced in 2013 by the hospital. There were concerns about dysfunctionality in the claimant's department and various incidents involving patients. It seems that the three surgeons in the department had significant interpersonal relationships with difficulties with each other, with apparently tit-for-tat concerns being raised. In an attempt to resolve matters, the employer introduced departmental rules and responsibilities which set out the rules and reporting requirements in a number of areas. The surgeons were warned that there would be a, quote, robust, unquote, follow-up if there was non-compliance. All three of the surgeons ended up being investigated for non-compliance, and the claimant was dismissed. The decision to dismiss was based on a pattern of conduct which, in the employer's view, gave rise to concerns about patient safety, but there was no single act that could have been said to amount to gross misconduct. Well, in my view, this looks striking like the last straw doctrine operating against the employee rather than, as usual, against the employer. It wasn't the term last straw doctrine doesn't apply in the decision, but I think by analogy that's what we're talking about here. The Employment Tribunal accepted that the misconduct allegations had been looked at carefully by the employer, and that the employer considered the claimant continued to pose a risk, and that the claimant would not modify his behaviour in the future. The tribunal, by a majority, accepted this belief was a reasonable one, and that the employer was able to come to, having followed a reasonable investigation and a fair process. Therefore, on that basis, by a majority, the Employment Tribunal found the dismissal fair. The minority took the view that dismissal was outside the range of reasonable responses. Of the various grounds of appeal, I just want to pick out two. The first ground was that the tribunal had misapplied the test as to the range of reasonable responses so as to justify dismissal. It was a first disciplinary hearing faced by the claimant. The employer dismissed without taking any steps to improve the claimant's conduct through disciplinary action short of dismissal. Secondly, after the dismissal had gone through, the GMC had taken a different and more lenient view of the claimant's conduct. The claimant asserted that the tribunal had been wrong to decline to review its original decision. Here, in essence, the AT accepted that the tribunal was entitled to come to the decision it did. They pointed to an earlier decision in Children's Aid Society and Day, where it was said that summary dismissal is not ordinarily the outcome for a first disciplinary hearing, but that it may be proper and reasonable to dismiss for a one-off offence, quote, especially with a man who is determined to go on in his own way, unquote. That was the case here, according to the employer's evidence, that was accepted by the tribunal. In the circumstances, the court said the failure to provide an opportunity to improve was justified and did not render the dismissal unfair. Turning to the outcome of the GMC inquiry and the tribunal's refusal to reassess the credibility of the respondent's witnesses, according to the claimant, it would have been highly relevant to look at the view that the GMC took of the situation and the assessment of the employer's evidence, and the GMC's view that he posed no threat to patient safety. However, the employer and the AT both disagreed with what the claimant was saying. The tribunal's refusal to reconsider was not perverse. The court did not accept that the subsequent finding by the GMC would have been likely to have had an important influence on the outcome, because the tribunal was considering a different legal question from that being considered by the GMC. The Employment Tribunal was, of course, considering whether the respondent had reasonable grounds for believing the conduct complained of had occurred, and it was material to that he had failed to satisfy the employer that such conduct would not reoccur. That did not form part of the GMC's determination. The court then went on to say that there was a considerable need for caution before tribunals felt compelled to reopen a case based on a regulator's subsequent determination of issues. There was a strong interest in the prompt determination of employment claims and the finality of judgments. This would be undermined if tribunals were too ready to reopen matters in the light of a regulator's subsequent ruling. Also, the regulator's concerns and approach are unlikely to be the same as in the Employment Tribunal. The AT here accepted that, in principle, there might be cases where it was appropriate to reconsider matters, but such cases were likely to be, quote-unquote, rare. I think there are 2 points coming out of the case to emphasise. First, the comments about the regulator's subsequent determination are important. We've seen this with things such as a decision whether or not to prosecute an employee when they've been dismissed for some alleged misconduct at work, theft, for example. The decision on whether or not to prosecute, or indeed a prosecution that leads to an acquittal, is very different from the tests an employer must consider before dismissing fairly. And as we see an increasing number of areas where there's a regulatory framework applicable, clearly employers will be pleased to have this decision, which re-emphasises that regulators and tribunals are often considering different questions, I should say. Secondly, the fact that here this employer was able to dismiss fairly, even though there was no single act of gross misconduct, and was able to dismiss fairly for a first offence, is helpful. The court accepted it was crucial to the finding that the employer believed there was a continuing risk, and the tribunal accepted this even though the individual had by then worked for a further 16 months while the investigation was going on without any problems. So I think it will also be a rare case where the employer is able to rely on this case to justify dismissal. Nevertheless, if companies have lost trust and confidence in someone's ability and willingness to comply with rules in relation to significant matters, I think this case could be very helpful. So that's the claimant's name, MBUB AEGBU, and Homerton University Hospital NHS Foundation Trust. So that's the end of podcast 135. Thank you very much indeed for listening. No cultural recommendations for this one, but be warned, we are heading into the time of the year when I spend my weekends off at music festivals, so there'll be a whole slew of recommendations, I'm sure, coming out of that. In the meantime, just remains for me to say that, as usual, no employees were harmed or mistreated in any way in the making of this podcast. Thanks very much indeed.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.